that it was going to relabel its Western Union money order as the Western Graham, it would be Delaware's position that that's no longer a similar written instrument, or that's no longer money order.
I guess I'm not quite sure I understand. Do you disagree that the agent checks and the teller's checks are typically, generally, whatever, for significantly higher value than a traveler's check?
Just like the agent check money order could be, Your Honor, because it doesn't have a limit. So yes, they are typically bought in higher amounts, but we don't think that that's really a substantive.
Okay, but that is, he's suggesting that as a distinction. Do you disagree that the agent checks and the teller checks are typically drawn on existing accounts while the traveler's checks are not?
Again, because they're bought at financial institutions, people will oftentimes buy them where they do their banking. I agree with that. But the drawn-on language is not actually correct there. Instead, what you're doing is you're prepaying for an instrument. You may deduct the money from your account, but it's a separate financial instrument. So it's not like an ordinary check, for instance, is drawn on your bank account. These instruments are not drawn on anybody's bank account.
If money order is as broad as you're saying it is, what's left for similar instrument?
I think, Your Honor, when Congress uses phrases like money orders, traveler's checks, and then follows it by a catch-all, I think what that oftentimes reflects, as this court has said, is Congress is concerned with covering the field and not leaving any loopholes. So it may very well be that in 1974, there wasn't a product that existed that wouldn't meet the core definition of what a money order is.
It was just like a in case.
I think
just in case something comes up or we missed something or whatever.
That's one way of looking at it. The other option is it's to ensure, if you accept Delaware's frontline argument, to ensure that you can't simply change the label on an instrument and have it be something.
Yeah, but it might be, right? I mean, I think that this is the strength of Mr. Katyal's argument, that they were thinking of something called traveler's checks. They had used traveler's checks. And they were thinking of something called money orders, like the prototypical things that the Chief Justice was talking about. They had seen money orders. They had used money orders. And then they said, you know, maybe there's some stuff that functions in the same way, that does pretty much the same thing, that has similar characteristics, whatever the relevant characteristics are. So we'll put that third thing in, you know, other similar things. So that seems to me a more likely way of drafting. It's like you have a particular product in mind and another particular product in mind, and then you realize that there are products you don't know about that might function in the same way.
And that is, we don't disagree that that's a possibility for what happened here. I just think that the way Congress when it used the term money order in '73, yes, we might now today typically think of an instrument that's sold at a retailer, but the fact is Delaware's own sources describe money orders as instruments sold at financial and non-financial institutions and that did not have low dollar limits. So I think they are money orders, as Judge LaValle said, under any common ordinary understanding, but I agree that at a minimum, they are certainly similar written instruments because they operate precisely like the instruments that we all agree are money orders. And if I can address briefly one of the labeling points that I think the other side made, that they pointed out, you know, people generally things are labeled consistent with what you would think they would be. And I think that's right. You know, they don't identify another product sold by another institution that works like these. And that's because this is basically a product where money order had a business model of selling money orders, and it didn't want to alter the structure of how it does things. So it put a different label on it and sold it somewhere else in order to appeal to a different end of the market without fundamentally altering the product itself, because they still operate exactly like money orders. Just like a retail money order, you go in, you prepay for it, you get a written instrument in response. The selling financial institution is merely an agent of MoneyGram. It's not a party to the instrument. It's an agent of MoneyGram. And the day after a transaction takes place, it forwards the money to MoneyGram, the selling financial institution does. At that point, whether we're talking about their so-called teller's checks or agent checks, that selling financial institution is entirely out of the transaction. It has no more role. That is the same role that Western Union played on classic money orders in the 1970s.
Can I mention a number of different things and ask you to tell me whether you think they are subject to the FDA? So the first one is a conventional cashier's check or a teller's check issued by a local bank and used to pay its own obligations.
So I would say it's under our definition, it doesn't meet our definition of a money order. We have not taken a position necessarily on whether it's a similar written instrument, but I think that there are reasons for believing that it is not, because again, that is not an instrument that would present the windfall problem as Your Honor framed it.
And what about a conventional cashier's check or teller's check issued by a local bank and sold to a bank customer. Same thing?
Yeah, again, Your Honor, they would typically keep addresses. In 1974, certainly for cashier's checks and classic teller's checks. If I can briefly just add to that, because we've talked about teller's checks a lot. These instruments, I know I've said this, but to make clear, these instruments are not traditional teller's checks. They label them as teller's checks, but they do not operate like traditional teller's check. So a traditional teller's check, as it existed in the 1970s, was an instrument, yes, signed by a bank officer. They're right about that part, and they stopped reading basically at that point. But the rest of the definition is signed by a bank officer drawing on funds of his bank at another financial institution. The difference with these items is that's not what's happening here. The signing officer is not drawing on funds of his own bank anywhere, which also indicates that they don't even meet the definition of bank check.
But are they still liable in the teller's check realm?
So there is some jumbling of the record on this point, unfortunately, Your Honor, but I think what Delaware's expert ultimately said is at most they might be secondarily liable, but the ultimate liability with the so-called teller's check instrument is MoneyGram, because MoneyGram is the issuer.
How about a prepaid cash card? Some grandparents always used to send their grandchildren a MoneyGram for Christmas. And now they want to become more modern, so they send them a prepaid Visa cash card.
Not covered either as a money order or a similar written instrument because it has to have a named payee, and gift cards do not have named payees.
How about a gift certificate that does have a named payee?
Again, I suppose it's possible if that instrument were a draft. There's not really any record development on this point that we could quibble about that, and I know that there are some states that do cover instruments that have statutes that would cover escheatment for instruments like that. The reason why I'm struggling with that one is I don't know all the characteristics of a gift certificate as opposed to a gift card.
You seem to be trying very hard to exclude various kinds of products. Why is that? Why not just say, okay, they're all included? That's good.
Well, I think, Your Honor, that when Congress uses, to go back to the language of the statute, when it says money orders, traveler's checks, or similar written instruments, it's referring to two things that had traveler's checks and money orders that had understandings in 1974 that we can rely on. And by using that terminology and using those two instruments as an example, other similar written instruments must share some of the core characteristics of what those two instruments share, so I think Congress decided to limit it. On one point of agreement is I think it's probably true, and the American Bankers Association says this as well, if Congress wanted to include cashier's checks, classic cashier's checks, it probably would have said that. It knew what that instrument was. They were well-known instruments at the time, but they didn't present the windfall problem because, again, addresses were kept typically for cashier's checks just as they are today.
I assume that gift cards don't escheat, even if they fall outside of the FDA, as you say. They're not subject to the common law rule of escheat, are they? So that does anyone get them? I thought the reason why stores like them is because a lot of times people don't use them and they just get to keep the money.
I think, Your Honor, there's been a development over time in the law as states have realized that there are these things out there that certain states have passed statutes. I don't believe that all states have, and I think Arkansas does not have such a statute, but I think it's just been a development as these things have become more popular.
Can I ask you a question that kind of goes sideways? At places in your brief, you indicate that you're after not just a declaration of rights here under the Disposition Act, but you actually want money damages for past wrongful takings of monies you think belong to your states. What is the cause of action that permits that? Is that an implied cause of action under the Disposition Act? I'm just curious if we were to agree with you, what happens next and on what theory?
So I think it is an implied cause of action under the statute, but I would add that we have not litigated the damages issue or the question. Those kinds of arguments haven't been presented to Judge LaValle because the parties agreed to bifurcate the proceedings here. So we haven't addressed any of the damages issues. But as for things I know Delaware discusses in its brief, the possibility that it could need to repay this money. But what I would highlight is, anytime we're dealing with unclaimed property, the state is essentially holding it in trust. It's not the state of Delaware's money. It's not really our state's money. We hold it in trust for the true owners. So requiring it to pay that money to the appropriate state, which will hold it in trust for the actual owners, Delaware really doesn't have any reliance interest there that would be upset.
But whether there's such an implied cause of action under the Disposition Act would be something that the special master would have to resolve after this
For the damages issue, yes, Your Honor. I think that's something that can be
Thank
resolved
you.
in there. There's one other point or a couple of points I wanted to briefly address. I've mentioned briefly the bank check thing, but I want to make sure I make this clear. Delaware's definition of a third-party bank check, setting aside whether an issuer or processor could be a third party in 1974, and it can't for the reasons the experts explain. But these instruments don't even meet Delaware's own definition of a bank check. So Delaware says that in order to be a third-party bank check, something must first be a bank check. As I mentioned earlier when we were discussing teller's checks, a bank check, and this is really, you've only been offered two sort of reasonable readings of what that term meant in the 1970s or even today. One of which I'll call this sort of technical definition. This is at page 37 of their exceptions, where they say that a bank check is an instrument that's signed by a bank officer, and as I said before, they stopped reading at that point, but it actually says drawing on funds deposited in the officer's own bank, that's a classic cashier's check, or drawing on funds of the officer's bank deposited in another financial institution. That's a classic or traditional teller's check. Again, that does not describe these instruments here. When the bank officer signs, one, he's signing as an agent of MoneyGram. To the extent that's not already obvious as a functional matter, the contracts between MoneyGram and the financial institutions make very clear. The financial institution is an agent of MoneyGram. So it doesn't, these instruments don't meet that definition because he's not signing to draw on any funds that are in control of the selling bank. Instead, it's MoneyGram that has the money, and it's MoneyGram that is responsible for paying the drawee bank or for reporting the unclaimed property. The other definition of bank check that you've been given is a broader definition than that, and it's the definition that Brady's Law of Bank Checks, which is again reproduced in Delaware's appendix, gives for bank checks, where it describes a bank check as both that technical definition that I just mentioned, but also ordinary checks. Or in the 1970s, going all the way back until World War I, bank check had been used as a term under Brady's Law of Bank Checks to both mean those specific instruments issued by banks, but also ordinary checks, and that's part of why a third-party bank check, ultimately, what that phrase means, if we're in the similar written instrument provision, is an ordinary check.
The impression I got reading your arguments and your friend's argument is that nobody has much of an idea what a third-party bank check is. Is that a fair?
That's fair, Your Honor. I think that we are, however, stuck with two things. We have to at least try and figure out what the terminology could have meant using similar phraseology in the 1970s. And, again, they've agreed that it has to at least be a bank check, and we're in agreement there. Something must at least be a bank check, and these don't meet that definition. But in terms of what the entire phrase could have meant, again, this is another example where I think you've only been offered two realistic options based in the way similar phraseology was used in the 1970s, neither one of which would describe these instruments. So Delaware says that in the phrase third-party bank check, the third party refers to an outside issuer or payer. The problem with that is that that's not the way third party is used on a financial instrument. It wasn't used that way in the 1970s. All the experts agreed on that. Instead, when somebody referred to the third party on a check or third party in a financial instrument, that third party reference was always a reference to a payee or the party that ultimately got paid on an instrument. So sometimes, for instance, it was used like in the twice endorsed check definition, where third party check is a common enough phrase then and today that it's actually defined in Black's Law Dictionary as a twice endorsed check. So the third party on that instrument is the endorsee, the third party to the original transaction who's the payee on that instrument. The other way the phrase third party and check got used in the 1970s was in the context of third party payment services or third party services. And there again, the reference was always to the party that ultimately got paid, the payee. So a third-party payment service, as the Hunt Commission explained, but it's not the only example, is a mechanism whereby a deposit intermediary transfers funds to a third-party payee, a third-party account holder, upon the orders of the depositor. So again, there, that phraseology is used to reference the ultimate payee. It's never been used, and Delaware doesn't cite a single source where it was used in the 1970s to refer to an outside issuer or processor. And what that means is they've offered a definition that is no way anchored with the way the terminology was used in the 1970s.
And don't we also have the legislative history that suggests that the inclusion of third-party bank check was supposed to be a technical or minor change? The thing that is a little concerning to me is that if it is used to exclude instruments that function like money orders, then we're talking about a huge carve-out to a statute that was designed to solve the inequitable escheatment problem in a way that doesn't seem technical or minor.
I absolutely agree with that, Your Honor. That the Treasury, when it requested this, and it's undisputed, yes, it's legislative history in some sense, but it's really drafting history. Nobody disputes that Treasury requested this exception. And Treasury characterized it as a clarifying amendment that was designed to cure an ambiguity in the statute, which suggests that it was sort of the narrow change to the statute to make something doubly clear. And I think defining a third-party bank check as an ordinary check really fits that characterization of a clarifying amendment and a narrow sort of belt and suspenders approach to make sure that ordinary checks, which obviously do not present the windfall problem because, one, we have addresses because we have account information, right, but also aren't prepaid. So that is entirely consistent with that sort of legislative history.
I guess they failed in that endeavor to make things doubly clear.
So the generous version of this, I think, Your Honor, is that the way the phraseology was just sort of used at the time. We're sitting here 50 years on, and banking regulators have their own terminology. But the thing that I would emphasize is that third-party payment was, in fact, is pointed out at Arkansas's appendix at 177, so common that the Washington Post said that a third-party payment today means essentially a checking account. So that was ordinary phraseology that maybe has gone by the wayside, but it is phraseology that was used at the time.
Your argument is that in 1974, everybody would have known what a third-party bank check means? I actually do remember 1974.
I think banking regulators might have known what it meant, maybe not ordinary people, but...
Thank you, Counsel. Justice Thomas, anything further?
Do you think we do more harm or less harm if we take the special master's suggestion that we decide this case without adopting a firm definition of money order?
So
that's what he tried to do, correct?
Correct. I think, Your Honor, that Judge LaValle's approach made sense in that under any ordinary understanding of the term money order, as the sources, Delaware sources, again, the ABA report on money orders from the late 1950s, the Compton's Encyclopedia, define money order. It includes instruments sold by financial institutions, not in low dollar amounts. And it includes instruments like the agent check money order here. And I think that is when Congress adopted the term money order.
You haven't answered my question.
I think that it meets any ordinary definition. So I don't think that it does any harm to define it that way. I know we started with a parade of horribles, for instance.
Do we do less parade of horribles if we define it your way? Because you take care of cashier's checks and I presume certified checks by calling them a prepaid draft, correct?
Correct. The reason why I struggle with this is I think both things are neither one does that much harm because, again, they're alluding to this possibility of a parade of horribles, but they don't point to anything that would present that parade of horribles. Cashier's checks, even if
you waited how long to sue? They're afraid of all the guys who are going to come and sue now. And they have good reason to worry because once we write a decision, the world will have the roadmap.
So what I would say to that, Your Honor, is that at least outside of the context of this case, I'm not aware of a situation where they allude, for instance, to private realtors, not to states having brought suits over cashier's checks. And even in those cases, nobody that I'm aware of is arguing that a cashier's check is a money order. Instead, those cases are all about the similar written instruments clause. But either way, I don't think that our definition, as I started by saying, necessarily requires treating them that way. I think they're well-known instruments. And if Congress had intended to include them, it probably would have used that language because they were well-known instruments at the time. And they just don't fit what Congress describes in 2501 as a money order because they're not instruments for which addresses weren't kept as a business practice.
Thank you.
Justice Kagan? Gorsuch? No? Justice Barrett? Justice Jackson?
One final question. Justice Kagan pointed out that Congress might have been intending to cover the field with this statute. And I guess my question is, so what is the field? It seems as though your friend says that really Congress was worried about no addresses, and as a result, large money instruments wouldn't fit in the statute because there was an incentive to have addresses. And I understood you to be focusing on Congress's concern about inequitable escheatment, in which case these instruments would be covered. So can you just, as a final word here, talk about what the purpose of this statute is?
Well, I'll start with the purpose of the statute is to address those instruments that presented the windfall inequity problem associated with the court's common law rule. I think what they're suggesting is there would be an incentive to keep addresses for larger dollar instruments. However, this case is a prime example of that hasn't happened. These are larger dollar instruments, and MoneyGram does not keep addresses. And it's the point here is that it's the issuer. It's the party that is actually responsible for paying these instruments. It's the party that holds the unclaimed property, and it hasn't kept those address information. So, I mean, to the extent Delaware is suggesting that that somehow makes a difference here, the record just doesn't bear that out. But again, going back to the other point about, Congress's actual concern was not just the low dollar instruments. Congress's concern was that requiring addresses to be kept for money orders as a class of instruments and other similar written instruments would be an additional burden that is not justified in light of the fact that people buy these instruments where they do their banking. They buy them in their home state. So if you required addresses and all the burdens that go along with that, it's simply going to reflect the same place. So what Congress is saying in 2501 is, to use Learned Hand's phrase, the game is not worth the candle here. Congress just decided it was easier just to have these instruments that sheet to the state of purchase, regardless of what their value would be.
Thank you.
Thank you, counsel. Rebuttal, Mr. Katyal?
Thank you, Mr. Chief Justice. 5 points. First, as the Chief Justice said, they can solve this problem easily by saying MoneyGram has to have the information. The information's already being collected by the banks. The only question is closing that informational hiccup, and that's a lot better, Justice Sotomayor, than the instrument-by-instrument litigation that will be invited by their approach. His answer to that was to say, to the Chief Justice was, well, Congress put its thumb on the scale. They did with respect to those two instruments. The question in this case is, did they do so for anything more than that? And the reasons why Congress isolated those two instruments don't apply here. The other point is, Congress is the solution to this, even if you don't think states will have this easy fix, which I can't understand to this day why they haven't done it, but Congress can, of course, do that. That's what you said in the Delaware case in 1993. If you're worried about equity concerns, Congress should fix it. And what did you point to in that decision? You literally pointed to 2503 and said, that's the solution if you're worried about equity concerns. Second, with respect to third-party banks, my friend says that there's no expert testimony that supports our position. That's a misreading of the record. The expert, Ron Mann, just didn't support our position on the words directly liable. Back down below, as this case comes to the court, we agree Professor Mann was wrong with that. But with the definition of third-party bank check, I think, Mr. Chief Justice, you said, well, nobody really knows what it means. We actually think the Hunt Commission does know what it means, and they told you what it means in that report, and that says teller's checks are included. Now, my friend says, this is our third point, that cashiers and certified checks are different. Well, first of all, note that he doesn't disclaim them. He says, well, we're not necessarily saying it. There's already litigation about cashier's checks and certified checks, as the ABA brief points out. There have been key TAM lawsuits that have been filed. He says, well, cashier's checks aren't prepaid. Most cashiers and certified checks are prepaid. The only ones that aren't prepaid are the ones in which banks are paying their own expenses. And our brief explains why we think those types of checks are covered under the statute. Fourth thing, Justice Sotomayor, you had said, or excuse me, Justice Jackson, you had said, the question in this case is, what is the field that Congress occupied? Congress knew exactly how to write the statute they want. They had the 1966 example. They didn't do that here. They wrote a much more narrow statute. And if you define, Justice Jackson, a money order as anything that transmits money that is prepaid, you blow up the statute. It means you can't explain what traveler's checks means. You can't explain what is left for other similar written instruments. Everything would be a money order. Nothing would be similar to it. And that's why Congress, and we think you should look to the rationales behind what Congress did. You pointed to the legislative history in the Treasury Department, but the Treasury Department just says essentially that this is a belt and suspenders fix. It doesn't say that something like teller's checks, which the Hunt Commission defined as being a third-party payment system, wouldn't be included. And finally and last, if you adopt our solution, the common law, it incentivizes exactly the kind of concerns that Justice Alito is worried about in Yee. It avoids any questions about these other instruments, from gift cards to cashier's checks to bearer's bonds and the like, and it avoids threatening the common law primary rule, because the primary rule is creditor addresses. And Justice Thomas, your opinion in Delaware said that has venerable old roots going all the way back to Old England. If they win, forget about place of incorporation. If they win, the primary rule of the FDA will control, which is to move away from last creditor's addresses. That is something that there's been zero support that my friend has offered on the other side for, and that's why that old presumption that you read statutes to avoid derogation of the common law has special force here. We don't doubt, can you read the statute the way my friend does? You can. But if you do so, it doesn't make sense of the statute and threatens all sorts of other financial instruments. And as the ABA says, that's something you should be really, really concerned about in this unique area, particularly because, as Justice Sotomayor points out, this litigation can go all the way back to 1974 and unwind not just the two disputed instruments here, but every other financial instrument. The safe thing to do is what you've done in case after case, which is to say, if we're concerned about equity, that's
you.